Good morning.
Good morning.
Morning, Your Honors.
Welcome. My name is Eric Eisnagel. I'm the presiding judge today. Welcome to an oral argument session of the 5th District Court of Appeal. On the panel, we have Judge Harris and Judge Wozniak. So that rounds out your panel today. Our first case on the docket, we only have two. At 9 o'clock, we have case number 2129, Central Florida Medical and Chiropractic Center versus Progressive American Insurance Company. And with assuming that is correct, we will have the appellant start whenever you are ready.
Yes, good morning, Your Honors. My name is Greg Tayon. I am here for the appellant, and I'd like to address how I even got to argue this hearing based on the fact that Mr. Stein and Ms. Simoes were initially scheduled to appear for the oral argument. So I want you to know that I am not the unknown ringer in this case, brought in the 11th hour. Unfortunately, Mr. Stein and Ms. Simoes had unexpected emergencies that did not allow them to participate, but I am fully prepared. And with that, if it pleases the court, I'd like to go into the arguments.
Please do.
Thank you very much. Really what's at issue today is the following. It's whether a party to a claim proceeding under Florida small claims rules can collect attorney's fees and costs from the other party pursuant to Florida statute 768.79 in the proposal for settlement served upon the other party without invoking the civil rules of civil procedure 1.442, which is the offer of settlement rule. Now, the appellee wants you to answer the question in the positive so it can collect the attorney's fees and costs. The trial court erroneously ordered it was entitled to collect from the appellate and to ignore the mistakes made by it and the trial court in reaching that conclusion. Now, the appellate is asking you to answer the question in a negative based on the reasons articulated its initial and reply briefs. As for those arguments, I personally do not feel that I can do a better job than what was argued in the appellate's summary of arguments in its initial brief on pages 7 through 9, but I do think it's very important to give a brief summary of those arguments to keep the court on track of our position. And the arguments are as follows.
Let me ask you this, Mr. Tam, before you get there.
Yes, sir.
You talked about the summary between pages 7 and 9. On page 8, it's argued that absent strict compliance with 1.442, there can be no award of attorney fees. Is there any argument that in any way appellee did not comply with 1.442? That the proposal for settlement was not in strict compliance with 1.442? I mean, you're saying, I understand you're saying it doesn't apply to small claims, but did they in fact comply with what 1.442 tells them they have to do?
Your Honor, we don't get to that position for the following reasons. The appellee had filed a motion to enforce the proposal for settlement that it served based on rule 1.442 in Florida statute 768.79. However, as your honors know, a motion without a hearing has no force of law. We don't get to the point of whether or not the proposal for settlement that was actually served upon the appellate has any force of law because it was never addressed by the court.
So counsel, you're waiving any argument that the proposal did not comply with 1.442. Is that correct?
I'm waiving it because I don't think it becomes an issue.
Okay.
Yes, I'm waiving that issue. So, so going back to the position is that, like anything else is like, why are we really here? Now, in the appellee's reply brief, they would make you believe that we're here because there was some kind of intertwining between substantive and procedural law that somehow the Florida Supreme Court failed to provide a mechanism for parties pursuing their case under small claims to access the substantive right to collect attorney's fees from the other side pursuant to 768.79. And in absence of that procedure, that mechanism, that the law stands alone. As it says in the briefs, it's self-implementing because the rationale from the trial court would be, it's presumed that no law was enacted to have a ridiculous result. And in fact, that's one of the bases that the trial court used in ruling as it did, that it believed by mistake of law that there was no mechanism in place for the appellee to, in fact, access 768.79 when, in fact, there is. Now, the mistakes that were made are twofold. The first mistake was made by the appellee. They clearly believed, well, they clearly did not believe in the position they're taking now, and that's evident by the fact that of the three motions that they filed seeking enforcement of their proposal for settlement, they did so based on Rule 1.442 and 768.79. It's curious in the third motion that they actually withdrew the Rule 1.442 as a basis and strictly went on 768.79. I believe that's because the case was over. They realized their mistake, and now they only had that basis in which to pursue their motion.
Counsel, why? If we just look at, I do understand your argument that if we're just looking at 7.020, it certainly seems to suggest that 1.442 would not apply because it's not listed specifically, right? However, when we look at the language of 1.442, it kind of has similar language to 7.020 when 7.020 says, hey, here, generally speaking, here are the rules that are, quote, are applicable in all actions covered by these rules. But then 1.442 says this rule applies to all proposals for settlement authorized by Florida law and supersedes all other provisions of the rules and statutes that may be inconsistent with this rule. It's interesting language. It's similar to 7.020 in that it purports to state what cases the rule applies to, correct? And it even then says that it supersedes all other rules and statutes that are inconsistent. Why isn't Rule 1.442 by itself, why does it not, by its own language, apply to small claims? Small claims are actions that where proposals of settlement are authorized by Florida law, right?
Correct. I can tell you why. The reason why is because the Florida Supreme Court, in exercise of its constitutional authority to promulgate the rules and regulations in which to enact the laws that the legislative branch, created, decided not to. It decided that
you're missing my question entirely. Didn't the Florida Supreme Court promulgate Rule 1.442?
It did in addressing a very specific issue that's raised in appellee's brief, which was at the time that the rule was amended, it was to clear up the conflict between 768.79's unconstitutional, in essence, grabbing of procedural aspects that were left only to the Florida Supreme Court to address. Now, in addressing the constitutionality of 768.79, the Florida Supreme Court, and also as well as other cases that were decided at the time, which would be Timmons v. Combs and the Vorkin case, the Florida Supreme Court said, hey, listen, we're going to find 768.79 constitutional only because we get to provide the rule in which you get to access that law. Minus our rule, the law would be found unconstitutional. Now, what the appellee is asking you to do is to revisit Timmons v. Combs and revisit that time period.
Well, counsel, in your defense, the question I'm asking you, the appellee, I don't think the appellee's raised, but appellees don't have to preserve issues and because of tipsy coachman, right? And so I guess what I'm asking you is under the rule itself that the Supreme Court promulgated, 1.442, which has pretty expansive language saying that it applies to all proposals of settlement authorized by Florida law and supersedes all other provisions of rules and statutes. Why does that rule not apply to all civil actions where proposals for settlement are authorized by Florida law, as the rule says?
Well, in addressing the language where it usurps all other laws, that directly is addressing 768.79 and the procedural aspects contained within that law. That language was specifically—
Counsel, it says rules and statutes.
Now with the rules, it doesn't usurp the rules of small claims rules, because if you look at the very first rule of civil procedure, those rules says that they apply to all civil matters. However, in the rule, if you go down, it says it applies to all civil matters except, and then the court, using its constitutional authority, has set aside separate rules to deal with separate situations. It has a probate court and has its own rules. It has family law and it has its own rules. And it has small claims and it has its own rules. Based on the fact that the Florida Supreme Court, in its infinite wisdom, decided we are going to separate all the rules based on what we consider to be all civil actions, and we're going to identify rules that we think are appropriate in addressing those civil actions. Now, under small claims rules, the Florida Supreme Court obviously recognized what those rules were intended to address. And there's two issues that the Florida Supreme Court was intending to address in creating the Florida small claims rules. One, the first issue is you tend to have, and they're trying to promote a court of law in some rules that make it easy for pro se litigants to have their day in court and resolve their issues. But the other part, and this is the part that it confuses a lot of courts, is the court is also recognizing that based on the rule that matters are separated by value. So a small claims matter is separated because the amount in controversy is within the range, within the jurisdiction of that court. It is not the fault of the appellant or anyone that finds themselves in small claims court that they happen to have an issue that isn't greater than $5,000 or $8,000, depending on the time in which it was brought up. So the court, in addressing those two fact patterns, has decided that, hey, how we want to handle the proposal for settlement is we want to make it where we don't have it automatically invoked. There is a mechanism in place. That mechanism in place is the following. The mechanism in place is a party by itself and by its own motion, or the parties through stipulation, or the court by its own motion can invoke all the rules, including Rule 1.442. The reason why the Florida Supreme Court decided to do that, and it's not articulated, it's my belief that the reason why they did that is because the Florida Supreme Court wanted that issue to be addressed on a case-by-case basis. Why? Because the proposal for settlement has a real chilling effect on a party's desire to pursue its legal right. And that
that's an interesting policy argument. I guess I'm going back to the language. And look, you have a good argument in the sense that, I mean, I think it's there's some persuasive value to it for sure. I'm not suggesting that it's a frivolous argument at all. It's an interesting case, but what I'm trying to find out is under 1.442, it has the very broad language of saying this rule applies to all actions where a proposal is authorized by law. And then it says, and this rule supersedes all conflicting rules and statutes. And so then I guess your argument is, well, but you have to read that in context with Rule 1.010, right? That says, hey, this rule applies to all civil actions except for small claims rules, where the small claims rules apply.
And in that, then you would look for the mechanism the Florida Supreme Court enacted for cases.
But in that circumstance, wouldn't Rule 1.010's sort of general statement be superseded by Rule 1.442's very specific statement saying that it supersedes all rules and statutes that are inconsistent?
No, because again, you have to look at the context in which the rule was amended. The context in which the rule was amended was definitely addressing the conflict with 768.79. And I believe that the language is definitely used as a catch-all. Now, one important issue to not make light of is the fact that the Florida small claims rules were amended in 2020. At that time, the Florida Supreme Court could have easily included 1.442 anywhere. It could have included in 7.020B saying that, hey, when you have two parties represented by counsel, so now you have sophisticated, counsels presented that, because in 7.020B, they do. The Florida Supreme Court invokes automatically other rules that are not invoked in 7.020A. So the Florida Supreme Court already recognizes, hey, in this fact pattern, we want the following rules to automatically be invoked, okay? The Florida Supreme Court could have said, you know what? We also want Rule 1.442 invoked in that circumstance. And you know what? They didn't. They could have added a D. The D could have been the rules apply, but in PIP cases, Rule 1.442 automatically applies or is automatically invoked. It didn't. It has that ability. It clearly did not. It's not what wasn't said, it's what was said. They clearly left it out for a reason. And the reason being is that they wanted that to be addressed on a case-by-case basis. They did not leave out a mechanism. In no way, in shape, or form has the Florida Supreme Court denied a party under the small claims rule access to a substantive right found in 768.79.
Well, hang on a second, Mr. Tin. Let me ask you about that.
Yes,
There is a substantive right created under the 768 statute, right, that the legislature came up with to recover attorney fees.
Correct.
Under the mechanism you keep talking about, what if the small claims judge says, no, we're not going to apply 1.442 in this case? Does the judge have the discretion to take away that substantive right if that's the only mechanism to apply the PFS in small claims court? How does the judge given that right?
It's given the right because the Florida Supreme Court is given the authority to create the procedures to access that right. It'd be the same.
But the judge can just say no, right? He can say, no, we're not going to have, he can eliminate that substantive right to fees by just declining to adopt 1.442 in small claims court.
I believe that is the Florida Supreme Court's intent to allow each individual judge on a case-by-case basis.
Counsel, why wouldn't that be a violation of separation of powers, right? The courts creating no mechanism by which a party can access a substantive right created by the legislature.
Because what's happening now is what you're doing is you're looking at 768.79 in a vacuum instead of looking at the time. Now, if the Florida Supreme Court would have been addressed with this exact argument right now, I don't believe that it would have handled 768.79 the same way that it did at that time. I think that it would have attacked 768.79 and it would have changed it entirely. It would have said, if you're going to put that on us, then we will come up with what we believe to be the way to access that law. It's the same right as that. I believe that an inherent right that we would have is that every defendant is entitled to address the allegations by its accusers. Okay, that's a substantive right, one of the greatest substantive right we can. Guess what? In circuit court, you got 20 days to do so. Why? Because that's the rule. There are lots of substantive.
You have about 3.5 minutes left. I don't know how much you want to reserve. It's up to you.
I definitely want to reserve the last 3 minutes to address. Just in the time that I have, I really think that the order that how we even got here is a mistake of law. I think that
Can I ask one question really quick? I know we're running short on time, but what exactly needed to happen in your position for 1.442 to be invoked and for the proposal for settlement to be valid here? When did it need to be invoked? Could it be invoking all of the rules at one time? Could it have been invoked at the time that the proposal was served or at the time the motion to enforce the proposal was filed? What would have to happen there?
What would have to have happened was what the appellate did not do, which is it filed a motion. It filed 3 motions. It had to have its motion heard. A motion without a hearing to address the due process rights of the other party opposing the motion was not heard. Therefore, a motion without an order has no force of law. All it had to do
to invoke the rules, or are you talking about the motion to
enforce the proposal for settlement, which is based on Rule 1.442? That's what it would have happened.
They could have moved to invoke that rule in the motion to enforce the proposal.
Using 7.020C, which is the mechanism. Ironically, Chief Judge Zambrano of our circuit here has an administrative order that invoked all the rules pursuant to 7.020C, except Rule 1.442, which was left out. So the Chief Judge of our circuit believes that 1.442 should not automatically be invoked. So
or maybe he reads it the way Judge Eisnagel was asking you, that it's already invoked under its plain language. It supersedes all other rules.
I don't see that as the case because the basis for it was for invoking all the rules was to expeditiously handle PIP cases filed in small claims. And my understanding is the reason why it was left out is because it's a contentious issue and the chief judge left it to each judge to decide on his or her own how they want to handle this issue. I'd like to reserve the last minute.
Sure enough.
Thank you.
All right. All right, counsel for the appellee, you're recognized whenever you're ready.
Good morning, your honors, and may it please the court. I'm Ken Hazuri, counsel for Progressive in this matter. And I would start by saying that Judge Harris, you nailed it with your question. That's their whole position here, is that a trial court judge or the Supreme Court can override the substantive right established by the legislature to be able to create a right of attorney's fees by serving a proposal for settlement in quote unquote in any civil action for damages filed in the courts of this state. That is the opening phrase of 768.79, that proposals for settlement can be served in any civil action for damages filed in the courts.
Well, counsel, their point is, yeah, that sure, absolutely. You just had to follow the right procedures. You just had to use Rule 7.020 to properly invoke the proposal for settlement rule.
Well, as Judge Harris pointed out, under 7.027 or 7.020C, the trial court has discretion. It doesn't require the trial court to
counsel,
invoke the rule.
I mean, that would be a different argument, but you didn't get us to that point, did you? And below, you didn't get a denial from the trial court. You didn't get a ruling at all.
Well, sure, they didn't. That's correct. The trial attorney did not do that. But the point here is it's a constitutional issue, and this is a pretty straightforward case, but it involves critically important foundational constitutional issues.
What if Rule 7.020 said, and the proposal for settlement rule can be invoked in a small claims proceeding only if the a party moves to invoke it, and if so, the trial court must grant the motion. Would that be unconstitutional?
I'm thinking about that because I haven't thought about that question. If it said must, then I think there's an argument that it wouldn't be constitutional because the court would not have any discretion to deny the request if it were made by the party.
So you think that the trial court should have the discretion to deny
No,
a request to make 1.442 applicable?
absolutely not. The court has
Well, that's
no
what you-
discretion. Under your hypothetical, you said that the rule would read must. So
Right,
the court would not have
the trial-
discretion.
No, the trial court would have to grant the motion and make Rule 1.442 applicable.
Right. So there's no discretion for the trial court to deny it. So there is no discretion. So yes.
Correct.
Yeah. So that's why I'm saying it's the must in your hypothetical that I think is the material change there, because it doesn't give the trial court the discretion to deny a party a right to serve a proposal for settlement, an enforceable proposal for settlement in a small claims case. Under your hypothetical, it would create a procedure for a party to invoke that right. I would view your hypothetical, again, thinking about it off the top of my head, as something similar to Rule 1.525 of the Florida Rules of Civil Procedure, which requires a party to serve a motion for attorney's fees and costs within 30 days of the judgment in order to invoke their right to attorney's fees. That's a procedural mechanism. But if the party does that, then they've invoked their right, and there's no opportunity for the court to say, nope, you can't pursue attorney's fees. If you comply with that procedural right. I would view what you described as something analogous to that. If the rule said that should the party exercise its right to move to amend, to invoke Rule 1.442, the court must do it, you probably pass constitutional muster because there's no discretion in the trial court.
Okay, I misunderstood your answer. So you're saying that would probably be constitutional.
Off the top of my head, that would be my belief because of the must. Because
I mean, at that point, it would be a purely procedural requirement. Maybe a silly one, but nevertheless a procedural requirement. Correct?
I think that's a fair, again, analogizing it to Rule 1.525. I think that's a fair conclusion to draw.
Well, let's say
doing any research.
Let's take the language of Rule 1.442 out of the analysis for a moment, and we're only going to look at 7.020. If we're only looking at 7.020, it certainly seems like there's a procedural requirement that you invoke the rule pursuant to 7.020.
No, Your Honor. because when in the absence of Rule 1.442, the procedural mechanisms, which are actually set forth in great detail in 768.79 apply. And therefore, you don't need to go to the rule. You use the procedural mechanisms in the statute. And
So
Except
your
for one
position
point.
is that we only need to, sorry, Judge Snoggle,
No, go ahead.
that you're okay just following the mechanisms in 768.79 and not 1.442, because there are a little bit of differences. So in small claims court, a party only needs to follow that statute.
that is absolutely correct. Your
A
Honor.
follow-up question to that. So I guess this goes to the policy. That kind of makes it easier to enforce, in my opinion, because attorneys get tripped up all the time with these proposals for settlement because there was a lot of procedure in the rule and in the statute. Doesn't that make it easier possibly to enforce a proposal for settlement in small claims court, possibly when there's, small dollars at stake, a lot of pro se people? It makes it easier to enforce a proposal against possibly a pro se litigant who may not be able to defend as well as an attorney could in this situation.
Well, that's correct. But on the other side of the coin, it makes it easier for a pro se litigant in small claims court to serve and enforce a proposal for settlement for himself or herself. And that's the whole, as we said in our answer brief near the end, that's the conclusion to be drawn from this, is that in a small claims case where you have a lot of pro se litigants and it's supposed to be a more simple expedited procedure, it makes sense to have a more simple procedure for serving and enforcing proposals for settlement. And that is set forth in the statute.
Counsel, I don't dispute that Rule 1.442 is highly complex, perhaps unnecessarily so, but nevertheless, how do you deal? It seems to me your argument is, look, in small claims, we don't need a rule, we just need the statute, right? That's your argument, right?
Essentially, yes.
Yeah. So how do you deal with, I'm going to do the same thing, ask you the same question I asked counsel. How do you deal with the part of Rule 1.442A that says this rule applies to all proposals of settlement authorized by Florida law and supersedes all of the provisions of the rules and statutes that may be inconsistent with this rule?
Your Honor, you noted earlier we didn't argue that in our briefing, and you're correct on that. And I would tell you, if that's the way you get there, then okay. If that's the way, that proposal,
that'd be different than your argument, right? You would still have to comply with 1.442 and not just the statute under that reading, correct?
If you were to rule that based on the breadth of Rule 1.442A, it therefore applies in small claims cases, then yes, if that's your ruling, a small claims litigant, such as the litigants in this case, would have to comply with that rule to serve proposals for settlement. And again, I think you're okay getting there that way because you have still made it so that litigants can serve enforceable, small claims litigants can serve enforceable proposals for settlement in small claims cases without any discretion of the trial courts to say, no, we're not going to let you do that, which is what Mr. Tayon and his client are advocating for, which would be a gross stepping on the separation of powers based on the legislature establishing the right, a substantive right, in quote unquote, any civil action for damages.
Counsel, this sort of distinction matters though, because when writing an opinion, the reasoning matters, right? And so does an opinion say, hey, small claims, you just go by the statute, you just go by the procedures set forth in the statute? Or does the opinion say, no, Rule 1.442 supersedes all rules and statutes and applies, and therefore you have to comply? Let's say your case, your proposal for settlement hypothetically didn't comply with 1.442, but did comply with the statute.
Okay.
How do you deal with the language in 1.442 says that it's saying that it supersedes all provisions of rules and statutes?
So to answer your question, let me answer your questions in order. First of all, we believe your opinion should say that in a small claims case where Rule 1.442 has not been invoked, that the procedures of the statute apply. That is what I believe is the correct answer here. Okay. Why?
Why? Yeah, explain that to me. How do you get past the language, the superseding language?
Well, I accepted the idea that Rule 1.442 does not apply in the small claims situation because it wasn't one of the rules that was adopted in the small claims rule. I mean, we accepted that position in our briefing, so that would be my answer. I think that's something Mr. Tayon and I agreed on in our briefing. My answer would be,
Counsel, if I could interrupt you, this court doesn't have to accept that reasoning, right?
I agree.
So help me out. How would you deal with what does that language mean? Supersedes all of the provisions of rule and statute.
Okay.
If we can just apply the procedure set forth in the statute, then what does that language mean?
Okay, so here's what I would tell you I think it means, Your Honor. When this rule was passed, there were multiple proposals for settlement provisions, or at least there have been historically. And sometimes if you look at Rule 768.79, it refers to offers of judgment. And other of the rules, 45.061 and called them proposals for settlement. There was all sorts of different terminology and all sorts of different statutes. I think there were at least three of them at one time dealing with proposals for settlement or offers of judgment. I believe the purpose of the language, the broad language of subsection A of 1.442 is to say, whatever you call it, whatever statute you're moving under, you're exercising your substantive right under, this rule applies in actions, civil actions for damages that are governed by the Florida Rules of Civil Procedure. I candidly do not believe that language is written, again, Mr. Tayon and I have found common ground here, to say that, oh, well, this is going to apply in small claims cases too, even though the small claims rules do not expressly adopt Rule 1.442. I don't read it that way. Again, I believe the opinion should read, if it hasn't been invoked, follow the statute. Your Honor, you are free to reach the conclusion that you're questioning me on. And if you reach that conclusion, then I think you're okay constitutionally, because proposals for settlement can still then be served in small claims cases without any discretion of a judge denying that right. Okay, you're just getting there through a different path and using 1.442 to get there. And we can live with that. As we said in this oral argument earlier, Mr. Tayon has waived any argument that we didn't comply with Rule 1.442. So if you went there, that would require an affirmance of the fee judgment that was entered. And so my answer to you is, I don't think that language of Rule 1.442A was intended to say that this applies in small claims cases and everything. If you read it that way, that's certainly your prerogative. But I think it was made to kind of consolidate the idea of there's all these different statutes and what have you, and different terminology. And this rule applies in cases governed by the Florida Rules of Civil Procedure to all of those. That's what I think the intention was.
But the rule doesn't just say if there are statutes that are inconsistent. It says if there are rules inconsistent with this, that 1.442 supersedes. Sure. The small claims rule is a rule inconsistent with 1.442.
Well, fair. It says it supersedes all other provisions of the rules and statutes that may be inconsistent with this rule. I'm not aware of another rule that would be inconsistent with this rule. I don't know that the fact that it hasn't been expressly
counsel, I mean, the primary argument here is that 7.020 that the small claims rules exclude 1.442, and that the whole argument here is that in order for 1.442 to apply, you have to go through this procedural hoop of invoking it, otherwise it doesn't apply. How is that not inconsistent with a rule that says it applies to all proposals for settlement authorized by Florida law?
Judge, it's a fair point. And if you read 1.442A that way, and that's how you get there, as long as proposals for settlement can be served in small claims cases without any discretion of a trial court to take that away, whether it's under Rule 1.4, the procedural mechanism in 1.442 or the procedural mechanism in the statute, I think you're on constitutionally sound ground.
Counsel, was there a time period where the proposals, or whatever they were being called at the time, were being enforced pursuant to the statute where Rule 1.442 was not in existence?
You know, I tried to look at that history, and Rule 1.442 has changed so much. I believe there certainly was a disconnect between the rule and the statute in the early days. I did read a case when I was preparing for one that said the original, I think the rule pre-existed the statute, and it kind of tracked the federal rule that allowed costs to be recovered. And then the statute was created in 1986. And so I don't think at the inception there that the rule was the way it is now, which is designed to be purely procedural.
Am I misremembering, or was the rule just repealed entirely for a few years? Maybe I'm just misremembering.
I think what you're thinking of, Judge, and I think it's in the Timmons case.
Yeah, Timmons. Yeah.
Timmons just adopted, and this goes to show you that the statute does contain procedural mechanisms. Timmons said we're revoking revoking Rule 1.442 as it reads, and we're just adopting the statute, the procedural mechanisms in the statute in 768.79. And if you actually read the rule at that time, and you can find the history of it, it just says something like the procedures of 768.79 apply to proposals for settlement.
It actually referenced the statute.
That's right, which goes to show you there's procedural mechanisms in the statute that are, viable for serving and enforcing proposals for settlement. We would say in small claims cases where Rule 1.442 doesn't apply. So again, Your Honor,
The appellant would say that's because the Supreme Court adopted the statute, though, expressly, right? I mean, that's what they would say.
The prior version?
Right.
Yes, yeah. I think that's why we didn't make a big deal about that, because the Supreme Court adopts it. No issue. But my point is, that shows you at least that the Supreme Court saw that there was procedural mechanisms in the statute for serving and for governing proposals for settlement, at least at a time, felt that they were sufficient. It's not like the statute is devoid of procedures that small claims litigants can follow and thereby have an orderly procedure for proposals for settlement in small claims cases. The statute clearly has that. That's the point I'm making there. I do want to touch on some of the statements that Mr. Tayon made. He said proposals for settlement in small claims cases would have a chilling effect. He said that the Supreme Court said we don't want to have proposals for settlement. I can't read my chicken scratch. He basically raised policy arguments for why the Supreme Court said or didn't adopt Rule 1.442 in the small claims rules. And let me go back. He said the chief judge of the circuit has made a policy decision that if the trial judge doesn't think there should be proposals for settlement in a small claims case, then the trial judge shouldn't invoke the rule. All of that, everything Mr. Tayon said, is a policy issue for the legislature. That is the subject matter of substantive law. It is not grounds for the Supreme Court, or it's not a subject matter for the Supreme Court or the trial judges to be involved in. They are limited to procedure. So everything Mr. Tayon's telling you about, well, if you do proposals for settlement in small claims, it would chill litigation, and therefore that's why the Supreme Court didn't do it. The Supreme Court doesn't have authority to do that. That is an encroachment on the separation of powers. The decision was made by the legislature that in quote unquote, in any civil action for damages filed in the courts of this state, that including small claims cases for damages like this one, that proposals for settlement shall be, enforceable, shall be able to be used. And so everything Mr. Tayon tells you about why the Supreme Court supposedly didn't invoke Rule 1.442, it has no authority to make those policy decisions. Just as the trial judge in any small claims case has no authority or discretion to prohibit a party from serving a proposal for settlement when they have an action for damages, when they have the absolute substantive right to do so under 768.79 subsection 1. Any decision to the contrary is an encroachment on the separation of powers and an encroachment on the legislature's authority. If you get there by saying If there's no, in a small claims case and the rule 1.442 isn't invoked and the statutes procedures apply, that's how we believe it should be, you're okay. If you get there by saying rule 1.442 applies in all cases, in small claims cases, therefore proposals for settlement can be served under that rule, you're okay there for those reasons. And he waived that, any argument related to that. For those reasons, we ask that you affirm. Thank you for allowing me to go a little bit over.
Thank you, counsel. And counsel for the appellant, we'll give you a little bit of extra time as well if you'd like. So please proceed with your rebuttal whenever you're ready.
The Florida Supreme Court, in addressing the constitutionality of 768.79, found it to be constitutional only because it reserved the right to produce the rule in which had to be followed by all litigants in accessing that right. To rule otherwise, the ramifications of your ruling to uphold the trial court's decision would follow as such. Number one is you're effectively overturning Timmons v. Combs. Number two, you're making rule 1.442 completely superfluous. Number three, you're stripping the Florida Supreme Court of its constitutional authority to create the mechanism by which parties can access the substantive right created by the legislative branch. It has a mechanism in place. It was not followed. The appellee believed in the mechanism by filing its motion to enforce the PFS pursuant to 1.442. So it believed in the mechanism because it tried to follow it. It just was not successful in doing so. And lastly, what you're doing is, and this is not a policy issue, by allowing 768.79 to stand alone, you are basically denying pro se litigants from having the due process rights it would have under the present mechanism for understanding the ramifications of what could happen. Right now, under the rule in small claims rule under 7.020C, there has to be a motion. And a motion requires a hearing. At that hearing, the person subject to the proposal for settlement and the attorney's fees and costs at that point in time would understand what's at risk if I go forward. The way it stands now, if 768.79 stands alone, then there would be no notification that the person that's going to be used against would know that this is happening. It stands there.
Why does there have to be a hearing?
The mechanism,
why does there have to be a motion and a hearing? The judge can just do it on his own. There needs to be a hearing for that.
The judge could do it on their own, and the judge at the trial court level could have invoked rule 1.442 after the hearing at the trial was over. It chose not to, and instead had a mistake of law in deciding that there was
Counsel,
no.
And even if the parties stipulate that it's going to be invoked, the judge can still say, no, it's not. Even in the light of a stipulation between both sides to use this rule, the judge can still say, no, we're not doing that. Right?
I don't believe that that's the case because the rule 7.020C says that you can invoke the rules by stipulation of the party. There'd be no basis if the parties both agree that they're willing to go forward. Because remember, the proposal for settlement, the entire proposal for settlement is to put one party on notice that, hey, if you don't resolve this case, the other side can reach into your pocket and take out a lot of money. That's the substantive right. But there's a combination lock on that pile of money. And the combination lock is rule 1.442. That is how it's structured.
Thank you, counsel.
Thank you.
All right. And with that, we are in recess.
Thank you, Your Honors.
Thank you, everybody. Have an awesome day. Thank you so much for this opportunity.